Hi, and welcome to part 5 of Sachs Dornberger and Vita's 10-part webinar series focusing on COVID-19, the impact on insurance coverage and claims. My name is Bethany Barrese. I'm a partner at SDV, where we focus on representing policyholders nationwide and all types of insurance coverage issues. I began my career at SDV's Connecticut headquarters, and I worked there for several years before I moved to Morris County, New Jersey, where I can better focus on serving our clients in New Jersey, New York, and Pennsylvania. I also lead the firm's national bad faith practice. So today's webinar is going to focus on the role of bad faith in COVID-19 litigation. I'm really pleased to be presenting today with my colleague, Stacy Manobianca, who's going to begin our discussion today with an overview of the topic of bad faith. And then we'll discuss some of the bad faith litigation that's already being filed by policyholders around the country. And we're also going to discuss the steps that governmental entities are taking to protect policyholders from unfair claims handling practices during this pandemic. We're going to close out today with our recommendations and best practices for how policyholders can ensure that their claims are being handled fairly and in good faith. So with that, I'll turn it over to Stacy to get us started.
Hello, my name is Stacy Manobianca, and I am of Counsel here at SDV. Before joining SDV, I spent 11 years practicing law at a large New Jersey law firm, and I previously worked for an insurance company managing medical malpractice litigation. I really enjoyed representing policyholders in insurance disputes, and I'm happy to be part of the bad faith group here at SDV. First, what is an insurance bad faith? Every insurance policy has an implied duty of good faith and fair dealing. This is a result of an insurance company's superior experience, bargaining power, and financial resources. The duty of good faith and fair dealing requires that insurance companies act reasonably in processing, investigating, and paying insurance claims. Bad faith has been defined as when an insurer is subject to liability to the insured for bad faith when it fails to perform under an insurance policy without basis for its conduct and with knowledge of its obligation to perform or in reckless disregard of whether it has an obligation to perform. Bad faith insurance companies are governed by state law. Remedies for bad faith include compensatory damages, attorney's fees, and in some jurisdictions, punitive damages. Punitive damages are usually only available where the insurance company committed fraud or acted with actual malice. In the context of COVID-19 litigation, bad faith insurance practices will generally involve first-party insurance claims. These are claims where a policyholder seeks coverage under its own policy, usually a commercial property policy or a builder's risk policy, for its own losses such as business interruption. These bad faith claims are generally premised upon the wrongful denial of benefits, which can include a denial of claim without proper investigation, misrepresenting relevant facts or insurance policy provisions, or the failure to provide a reasonable explanation or reasons for denying a claim. These claims can also arise out of delays in claim processing. This occurs when an insurer fails to acknowledge a claim and act promptly upon receiving a claim. Insurance companies are required to acknowledge a claim promptly and make contact with insureds regarding the claim almost immediately after it's filed, or when they're put on notice. It also occurs when an insurer fails to either approve or deny a claim within a reasonable time after receiving the proof of loss from its insured. After receiving the proof of loss, the insurer has an obligation to act promptly to resolve the claim. With that, I'll turn this over to Bethany to provide us with some real-life examples of how bad faith plays a role in COVID-19 litigation and legislation.
Thanks, Stacy. So SDV has been tracking litigation around the country that's related to COVID-19 insurance claims. And the first case that I'm going to discuss today is Barbara Lane Snowden doing business as Hair Goals Club versus Twin City Fire Insurance Company. Just to put the timing of this case into perspective a little bit, the pandemic was declared by the World Health Organization on March 11th, and then this suit was filed on March 26, 2020 in Harris County, Texas. So this is one of the earliest COVID-19 related insurance coverage suits that we know of. And if you read the complaint, and there's a reference to the docket number there in case you'd like to look it up, or you can also find it on our website. The complaint alleges that Ms. Snowden's business suffered losses due to the COVID-19 outbreak and also due to Harris County's subsequent business shutdown order. So as a result of the business interruption, Ms. Snowden submitted a claim to her insurer, which is Twin City. And the complaint alleges that Twin City mishandled the claim, made material misrepresentations regarding the policy provisions and the applicable law, and also wrongfully denied coverage. And allegedly, all of this was done by Twin City knowingly. So the complaint was filed, and it contains a number of claims against Twin City. You have your standard breach of contract claim for failure to pay amounts owed under the policy. And then there are also 3 counts of bad faith that we'd like to discuss today. First, there's a claim for common law bad faith. And that claim alleges that Twin City wrongfully denied the claim, despite the fact that they had no reasonable basis to do so. Then there are 2 claims of statutory bad faith. The first is for violation of Texas Insurance Code Chapter 541. That statute prohibits unfair methods of competition and unfair or deceptive acts or practices in the business of insurance. Essentially, what Ms. Snowden is saying is that Twin City violated this provision by misrepresenting the policy terms, the facts, and the applicable law. And then finally, there's a count for a violation of Texas Insurance Codes Chapter 542. That's Texas's Prompt Pay Act. And what that does is it imposes deadlines on insurers for responding to claims, investigating claims, and accepting or rejecting and paying claims. The allegation is that Twin City failed to timely pay a covered claim. So the damages sought, why this is interesting and why bad faith is important here, is that Ms. Snowden is not just seeking to recover the amounts owed to her under the policy, but she's also seeking extra contractual damages. So she's seeking 3 times the amount of her lost business income, consequential damages, compensatory damages, court costs, attorney's fees, and interest. And many of those claims would only be available pursuant to a successful bad faith claim. So that's why it is so important. One of the reasons why we wanted to highlight this case is because it's been pending long enough for Twin City to have filed its answer, which they did on May 4th. And Twin City filed its answer in affirmative defenses, stating that they completed a full and fair and prompt investigation of Ms. Snowden's claim, that they acted reasonably, and that they had 1 or more good faith bases for a denial of coverage. It's all laid out in there, but the primary one that it seems to be resting on is that the policy has a virus exclusion, which precludes coverage for Ms. Snowden's claim. Twin City also asserted a number of affirmative defenses, and among them is a defense that Ms. Snowden failed to properly provide advance notice to Twin City before she filed her statutory bad faith claims. This is something that's fairly unique to Texas law. Not all states require advance notice of filing bad faith litigation, but Texas bad faith statutes do. So what Twin City did is it asked the court to hold the litigation in abatement until Ms. Snowden corrects the deficiencies and provides compliant notice as required by the statute. The reason why Texas law requires the abatement of litigation where notice was not properly provided was because they want to discourage this kind of bad faith litigation and encourage the out of court settlement and resolution of consumer complaints. So this is one great example of how bad faith law can really differ from state to state. Not all states have prompt pay acts like Texas does. Not all states require advance notice. So it is really that important to be sure that you conduct a choice of law analysis, know which state's law applies, and what kind of procedural aspects are correlated with that claim. The next case we wanted to go over is Big Onion Tavern Group LLC et al. Versus Society Insurance Inc. This is a case that was filed the day after the Snowden case. So this is March 27, 2020 in federal court, Northern District of Illinois. And this complaint alleges that there are several Chicago area restaurants, theaters, and bars that were shut down by government order. Initially, this suit was filed by 6 policyholders, but there were actually 42 more added by amended complaint that was filed on May 8th. So that's really interesting because it shows not only how many businesses were affected by the shutdown in Chicago, but also how many had the same insurer and how many alleged that that insurer handled their claim and denied coverage in bad faith. So according to the complaint, Society held their policies out as providing quote unquote best in class coverage, but then they issued denials, and sometimes those denials were issued within hours of receiving the claims for COVID-19 related losses. The complaint also alleges that society issued a memorandum to their policyholders stating that pandemic events are excluded, but allegedly the policies have no pandemic exclusion. So the claims that the policyholders have brought against Society Insurance, there's a declaratory judgment count and a breach of contract count, which are fairly standard. And then there's also a statutory bad faith count that was brought for violation of the Illinois compiled statutes for failing to conduct a meaningful investigation, failing to provide reasonable and accurate explanations for society's denials, misleading the policyholders about that pandemic exclusion, and allegedly society also directed its agents to make sham claim notifications in order to avoid paying losses. So the Big Onion plaintiffs are seeking damages under Illinois statute, which provides for recovery of damages, again, above and beyond the amounts that would be owed under the policy if the insurer's actions or delay is found to be vexatious or unreasonable. The amount of damages sought here is pretty significant. This statute permits the recovery of either 60% of the amount that the court or jury determines that the policyholders were entitled to under the policies, exclusive of costs, or $60,000 per plaintiff. And remember that this is a class action, so there are multiple plaintiffs, whichever is greater. And then the complaint also seeks attorney's fees, costs, and interest. So this is just another one to keep an eye on. Since it was an earlier filed suit, we should be seeing more developments in the near future. That's just a really small sampling of some of the bad faith litigation that we've seen around the country. We also wanted to focus not only on what private entities are doing to protect themselves and to recoup their losses for insurance bad faith, but also what governmental entities are doing in order to prevent bad faith from happening in the first place. So the first item that we're going to discuss is a Massachusetts bill. Like many states, Massachusetts has introduced legislation that would require certain insurers under certain circumstances to provide coverage for business interruption losses related to COVID-19. My partner, Richard Brown, goes over this litigation in great detail in part 2 of this webinar series, which is available on our website, www.sdblaw.com. So I won't go over the bill itself in too much detail, but I do want to note that the Massachusetts bill is unique insofar as it specifically states that the legislation is subject to Chapter 176D of the Massachusetts General Laws, which concerns, again, unfair methods of competition and unfair and deceptive acts and practices. That statute sets forth 12 categories of conduct that would be prohibited in the business of insurance. So that includes misrepresentation, unfair claim settlement practices, failure to settle claims promptly where liability is reasonably clear, and failure to provide a reasonable explanation for a denial of coverage. So by including this language in the bill, the Massachusetts legislators are sending a pretty clear message that if this bill becomes law, insurers have to comply with its provisions in good faith. The other thing that we've seen recently is a notice that was issued by the California Insurance Commissioner. It was issued on May 14th, 2020 to all insurance companies, adjusters, producers, licensors, all interested parties in the state. And what that notice says is that social distancing and stay-at-home orders have essentially reduced the functioning of the courts. Some of the courts have even been closed, which makes it really hard for policyholders to attain redress if they're being subjected to bad faith. And it makes them really vulnerable to insurance bad faith practices, such as unfair claims handling or unreasonable denials of coverage. The notice says that as far as the insurance commissioner is aware, certain entities may be taking advantage of that fact, of the court closures, and also the fact that policyholders right now, a lot of them have higher financial need than they might otherwise would due to the widespread closures of businesses. So essentially what insurers have been doing is providing unjustifiably low settlement offers, lowering settlement offers once made, or failing to make settlement offers to resolve claims entirely. So what the insurance commissioner did is they have directed all insurers to comply with the California Unfair Practices Act, which prohibits these unfair or deceptive acts or practices. The notice also warns that violators are subject to civil penalties up to $5,000 per act, or $10,000 if the act or practice was willful. This notice finally states that the commissioner intends to exercise full authority to pursue all remedies. So we have seen many states whose governments and legislative bodies are taking affirmative action to protect policyholders from bad faith at this important time. The last thing that we wanted to mention is that what we have seen in certain circumstances is that an insurer might attempt to retroactively modify the policy terms after the policy is issued. We are aware of at least one insurer who has attempted to modify a policy that was already issued pre-pandemic to include an endorsement that excludes coverage for virus and bacteria-related losses. So in this instance, the policy was issued pre-pandemic. The insurer tried to modify the policy by endorsement post-issuance, and their explanation essentially was that the exclusion was supposed to be on the policy all along. It was supposed to be added at the renewal. But if you look at the endorsement that was attempted to be added to the policy, it has a March 2020 issue date, which calls into question what date was this form authored, what date was it supposed to be added to the policy. So, generally speaking, mid-policy changes are permissible. It's not necessarily wrong for an insurer to modify the policy bad faith, but this needs to be done by the mutual understanding of the policies. Usually, mid-policy modifications are done at the policyholder's request, and they usually correspond with a change in premium, depending on the changes that were made. So there's a possibility that this type of behavior would constitute bad faith, and depending on the circumstances and what the insurer said, whether there were any misrepresentations, whether a reduction in premium was offered. So if you'd like to know more about this, my colleague Teresa Gurton wrote an article. Again, that's available on our website. And we just want to note that policyholders should be aware of any attempts to unilaterally modify policies mid-period, just because the insurance industry is really in flux at this time. So if your insurer sends you any notices, just be sure that you read them. So now that we've gone over the types of bad faith conduct that are allegedly occurring in connection with COVID-19 insurance claims, I'm going to turn it back over to Stacy to share some best practices that policyholders should implement to ensure that their interests are protected.
So how can a policyholder, in submitting our insurance claim, protect itself in the event of insurance bad faith, but also just ensure that the claim process will go smoothly? The first and most critical piece is to know your insurance policy. Every policyholder should have an opportunity to review a complete copy of their policy in advance of filing a claim. Ideally, you would have a copy of your insurance policy when the insurance policy is issued, but oftentimes that doesn't happen. And you only receive a copy of the declarations page, which evidences that you have the type of coverage that you purchased and what your policy limits are. But for example, that declarations page won't tell you if there's a exclusion for a virus or bacteria or sick building, which, as Bethany just discussed, could potentially preclude recovery in a COVID-19 scenario. The policy will also provide a roadmap for coverage, and it is essential that you're aware of the types of coverages are and are not provided overall. The second thing you should do is consult with counsel. Reviewing your specific insurance policies with counsel can provide valuable insight as to the types of coverage available, and the counsel can help you draft a roadmap to recover for those covered losses. It will also streamline the process. It's important that when you're submitting an insurance claim that you know what your policy covers to ensure that you're only seeking to recover losses that are covered under the policy. This will maintain the credibility of your claim and make it more likely that the insurance carrier will pay more promptly. Third, you should communicate with your insurance carrier early and often. Insurance policies contain conditions that require that a policyholder fulfill certain obligations in order to trigger coverage. Oftentimes, those conditions contain specific notice requirements and a timeline for the presentation of proof of loss statements. Most of the time, you must submit notice of a claim in writing to your insurance company as soon as practicable. So as soon as you're aware that there could be a potential loss. This should be done in writing then at the very first opportunity. It's important to consider the current shelter in place and social distancing requirements, and how those requirements can impact policyholders in satisfying those policy conditions. For example, policyholders are often required to protect their property and mitigate damages, or to provide an inventory of loss or a sworn statement about the claim. This might be difficult to do if the policyholder is unable to get to the property and obtain the documents that are maintained there. To solve this problem, policyholders should seek to provide the requested information to their insurer and utilize technology as best as possible to assist in the claim preparation. Fourth, when communicating with your insurance carrier, require written communication. Whenever possible, when you are communicating with your insurance adjuster, do so in writing. Email is convenient and it's commonly used by insurance adjusters. When I was adjusting claims, I more often emailed with my insureds than spoke to them on the phone. But if you are communicating with your adjuster by telephone, request they confirm your communications in writing so that you have a timeline and documentation of the way that the claim is being handled. If the adjuster does not want to provide an email confirmation, then it's incumbent upon the policyholder to write an email to confirm the conversation, and so that you have that as a part of your records. This is particularly important when an insurer is denying coverage. When an insurer is denying coverage, it will begin the clock to file any potential lawsuit against the insurer. Finally, keep a claim calendar. Track all of your correspondence with your carrier in a separate calendar. This will provide a timeline for the insurer's investigation of your claim. This can be particularly significant in states like Bethany had referenced that have legislation requiring prompt communication and payment of claims. Courts have determined that these statutory guidelines are not relaxed as a result of an emergency, and therefore insurers will be held to these statutory requirements.
Well, that's all we have for today. If you'd like to know more, you can check out SDV's COVID-19 resource page by going to our website, www.sdvlaw.com, and clicking on the News and Ideas section where you'll find the COVID-19 resources page. It contains a litigation tracker that notes the cases that we discussed today, plus all the other cases that we're aware of concerning insurance coverage, COVID-19 claims. And we also have a variety of articles addressing any topic that policyholders need to be aware of related to COVID-19. And I would also encourage you to stay tuned next week. Our part 6 of our webinar series is going to be released a week from today. So thank you so much for listening, and please feel free to reach out to either Stacy or myself if you're interested in discussing this topic further. And I hope you have a great day.